The HOA sent me a $500 a day fine for building a dam. I read the notice at my desk, set it next to my coffee, filed it. I'm a licensed civil engineer, also a water rights attorney, 40 years. When I design a dam, I read everything. The permits, the statutes, the regulatory bulletins, the stormwater plans of every development within 1 mile downstream. I had read theirs. Page 14. The Ridgeline Hollow Development's drainage pond was undersized for the watershed, deliberately. The engineer who designed it assumed the upstream land would always provide natural impoundment capacity to absorb the peak flows first. My reservoir increased that capacity by 210 acre-feet. They had been fining me for 6 months to remove the structure, keeping their streets dry. I let the fines reach $70,000. Then I cracked the outlet gate 1/4 turn. Their detention pond had 8 inches of freeboard left when Garrison Webb called me. He called on a Wednesday. The easement recorded on a Tuesday. Let's take it from the top. Before we get into it, share where you're watching from, and don't forget to like and subscribe for more great content. Emmett Cross had designed his first dam at 31 years old, a small agricultural impoundment on a family farm in the county's western range, a Class C structure by the state's classification, 12 feet high, a 140-foot crest, a 6-acre reservoir that had watered cattle and irrigated a hayfield for 40 years without incident. He had designed it on a drafting table in the engineering firm where he had worked his first decade out of graduate school, had supervised its construction over 3 weeks in the fall of 1986, and had stood on its crest the morning after the final compaction pass, and had looked at the upstream watershed filling behind it, and had thought, water does what you tell it to do if you ask correctly. He had spent 40 years asking correctly. The civil engineering career had built itself around water. Hydraulic modeling, watershed analysis, detention basin design, spillway capacity calculations, dam safety inspections. He had designed 11 dams across 4 counties, from Class C agricultural impoundments to a Class A municipal water supply reservoir, whose operating license was the oldest active dam license in the county's northern watershed. He had testified as an expert witness in 14 dam safety proceedings, 7 water rights disputes, and 3 federal wetlands cases. He had been retained by the State Dam Safety Office as a technical consultant on 3 dam failure investigations, the kind of work that required a practitioner who understood not just how dams were built, but how they failed and why. The law degree had come in 1992, 12 years into the engineering career, earned at night school over 4 years while he was running the hydraulic engineering division of a regional firm. He had taken the bar examination in the summer of 1992 and had passed on the first attempt. His motivation had not been to leave engineering. It had been to understand the legal instruments that govern the water he spent his professional life moving: the water rights permits, the operating licenses, the easement frameworks, the regulatory jurisdiction questions that determined who had authority over a given body of water and who did not. He had understood, by 1988, that the most important questions in water engineering were not hydraulic, they were jurisdictional. He had gotten the law degree to answer them himself. He had practiced both disciplines since 1992, the engineering firm and the law practice sharing an office suite, the 2 professional identities informing each other in every case he handled. A water rights dispute without an engineering foundation was a legal argument without facts. A dam design without a legal framework was an engineering solution that could be undone by a jurisdiction question. He had built a practice that handled both simultaneously, and in 40 years of combined practice, he had never encountered a jurisdiction question he could not answer from first principles. The 520-acre upstream parcel had come to his attention in late 2021, a former agricultural property in the county's northern watershed, the headwaters of Crestfall Creek running through its center. The parcel listed for sale by an agricultural holding company that had owned it since 1987 and had decided to liquidate its county land holdings. Emmett had driven the parcel in November 2021, the creek running at its fall base flow, the upstream watershed's topography forming a natural impoundment site at a bedrock outcrop crossing on the creek's center reach. He had stood at the bedrock crossing and had looked upstream at the drainage basin, approximately 1,200 acres of contributing watershed, the creek's gradient dropping 22 feet across the bedrock crossing's 40-foot span, the valley walls on both sides rising to natural spillway elevation, at 18 feet above the creek's normal flow line. He had pulled his field notebook from his jacket and had sketched the impoundment geometry. An 18-foot earthen dam at the bedrock crossing, a 280-foot crest following the valley's natural contour, the impoundment filling behind the dam to form a 34-acre reservoir at the 18-foot pool elevation. He had estimated the reservoir's volume, approximately 210 acre-feet. He had estimated the watershed's runoff contribution, sufficient to fill the reservoir in a normal precipitation year within 3 to 4 months of dam completion. He had noted the spillway configuration, a Morning Glory inlet at 17.5 feet, the overflow discharging through a concrete barrel culvert to the downstream channel. He had written in his field notebook, natural impoundment site, bedrock crossing, Crestfall Creek center reach, Class B dam feasible at 18 feet, 280 feet crest, 34-acre reservoir, 210 acre-feet volume. Watershed, 1,200 acres, adequate inflow. Spillway, Morning Glory at 17.5 feet, state permit required. Class B, Core 404 required. Wetlands impact assessment needed. Check county engineer files for downstream stormwater plans. That last notation, check county engineer files for downstream stormwater plans, had been the professional habit of 40 years of hydraulic engineering practice. Any dam construction on a creek with downstream development required a review of the downstream stormwater infrastructure to understand the hydrologic relationship between the proposed impoundment and the drainage systems downstream. It was standard engineering diligence. He had done it on every dam project he had ever designed. He had gone to the county engineer's office in December 2021 before submitting a purchase offer, and had requested the stormwater management plans for all developments within 1 mile downstream of the bedrock crossing on Crestfall Creek. The county engineer's records clerk had returned 3 plans: a 1998 agricultural drainage plan for a farm parcel that no longer existed, a 2001 road drainage plan for a county road improvement project, and a 2003 stormwater management plan for a residential subdivision called Ridgeline Hollow. 110 units, the development's southern boundary located approximately 600 feet downstream of the bedrock crossing on Crestfall Creek's eastern bank. He had read the Ridgeline Hollow stormwater management plan at the county engineer's counter, standing, his field notebook open beside the plan. The plan had been prepared by a civil engineering firm named Barclay Associates and had been approved by the county engineer in 2004. It had described the development's stormwater management system, a network of inlet structures, conveyance pipes, and a 2-acre detention pond at the development's southern end, the detention pond's outlet discharging to Crestfall Creek. The plan's hydrologic analysis section had described the receiving water body for the development's stormwater discharge, Crestfall Creek, a perennial stream with a contributing watershed of approximately 1,200 acres upstream of the project site. The upstream watershed's natural impoundment capacity provides significant attenuation of peak flows, reducing the development's required detention storage below what would be required for a direct discharge watershed. The design detention volume assumes continuation of the upstream watershed's existing natural impoundment characteristics. He had read that paragraph twice. Then he had read it a third time. The Ridgeline Hollow Stormwater Management Plan, approved by the county engineer in 2004, the governing drainage document for a 110-home development, had been designed on the assumption that the upstream watershed provided natural impoundment capacity that attenuated peak flows before they reached the development. The plan's detention pond had been sized below what a direct discharge watershed would have required, the design deficit made up by the upstream impoundment capacity that the plan assumed would always be there. Emmett had written in his field notebook, RH Stormwater Plan, 2004, Barclay Associates. Receiving water, Crestfall Creek. Design assumption, upstream watershed natural impoundment capacity attenuates peaks. Detention pond undersized for direct discharge watershed. Gap filled by upstream impoundment assumption. My dam increases upstream impoundment capacity by 34 acres, 210 acre-feet. HOA's drainage system already depends on upstream impoundment. My dam makes the dependency better, not worse. File this. He had purchased the 520-acre parcel in March 2022. His deed had recorded March 22, 2022. He had submitted the dam construction permit application to the State Dam Safety Office in April 2022. The complete engineering package, the dam design drawings, the hydrologic analysis, the spillway design calculations, the geotechnical report on the bedrock crossing foundation, and the downstream hazard assessment. The downstream hazard assessment had addressed the ridgeline hollow development. The dam's failure mode analysis had found that a Class B dam failure at the bedrock crossing would produce a peak downstream flow that exceeded the development's detention pond capacity, a finding that confirmed the Class B classification and required the Morning Glory spillway's design capacity to be sufficient to pass the state's 100-year design storm without overtopping. Emmett had designed the spillway to pass the 500-year storm, 2.5 times the regulatory minimum, because 40 years of hydraulic engineering had taught him that spillway capacity was the one design parameter where margin was never wasted. The Army Corps Section 404 permit had required a wetlands delineation and a compensatory mitigation plan for the 8.4 acres of jurisdictional wetlands the reservoir would inundate. Emmett had prepared both. The delineation conducted by a certified wetlands scientist he retained for the purpose, the mitigation plan providing for the creation of 12.6 acres of enhanced wetlands at a mitigation bank site in the county's southern watershed, a 1.5 to 1 mitigation ratio that exceeded the Corps' standard requirement. The Section 404 permit had been issued in September 2022. The state dam construction permit had been issued in October 2022. Construction had begun in October and had been completed in November. 6 weeks of earthwork, the dam's compacted fill placed in lifts by a licensed contractor under Emmett's direct engineering supervision, the outlet works installed, the Morning Glory spillway formed and poured, the downstream channel armored at the outlet. The State Dam Safety Office's inspector had conducted the construction completion inspection in December 2022 and had found the structure in full compliance with the permit's design requirements. Dam Operating License DOL-2022-041 had been issued December 19, 2022. Emmett had read the license at his desk the afternoon it arrived. The state's standard Class B operating license format, the licensed operator named as Emmett Cross, PEJD, the dam's location on Crestfall Creek described by its legal parcel description and GPS coordinates. The reservoir's normal operating pool set at 18 feet above the outlet works invert, the mandatory inspection schedule established at 10-year intervals, and the sole operator authority provision. The licensed operator has exclusive authority over the operation of the outlet works and spillway structures. No person, entity, or governmental body other than the State Dam Safety Office may direct, compel, or prohibit the licensed operator's exercise of that authority without the written concurrence of the State Dam Safety Office. He had noted the sole operator authority provision in his engineering log, the same provision, in slightly different language, that appeared in every Class B and Class A operating license he had reviewed in 40 years of practice. He had written DOL-2022-041 issued. Emmett Cross had designed the Ridgeline Hollow, HOAs. Violation Committee met on the second Tuesday of every month. The committee had 5 members, Garrison Webb as president and chair, the Architectural Review Chair, the Environmental Covenant Chair, the Treasurer, and 1 at-large member, and it operated with the procedural formality of a body that took its enforcement authority seriously. Violation notices were issued on HOA letterhead, violation fine schedules were published in the annual community handbook, and the committee's meeting minutes were posted to the community forum within 48 hours of each meeting. Garrison had organized the committee's procedures in his first year as president, standardizing the notice format, establishing the fine schedule, and creating a violation tracking spreadsheet that logged every open enforcement action by property address, violation category, notice date, and accumulated fine balance. He was proud of the system. He had presented it at the County HOA Association's annual conference in 2022 as a model enforcement framework. The system had one foundational assumption built into every procedure, every notice format, and every line of the tracking spreadsheet. that the HOA's CC&Rs applied to the properties and conditions the committee was citing. This assumption had never been examined against a jurisdictional question, because in 4 years of committee operations, the committee had never issued a violation notice against a condition on property outside the HOA's geographic boundary. Every prior violation had been against a Ridgeline Hollow property owner for a condition on a Ridgeline Hollow property, an unapproved paint color, an unauthorized fence, an oversized recreational vehicle in a driveway. The enforcement framework had been designed for those cases. It had never been tested against a licensed dam on a private parcel 600 feet upstream. The first violation notice had been issued on January 3, 2023, 14 days after DOL-2022-041 had been issued, 11 days after the reservoir had reached its initial operating pool level following December's precipitation. The notice had been mailed to Emmett's engineering office address, certified mail, on Ridgeline Hollow HOA letterhead. It had cited Section 7.4 of the HOA's CC&Rs, the Environmental Covenant, and had described the violation as construction and operation of an unauthorized impoundment structure on the upstream watershed of Crestfall Creek, materially altering the natural drainage patterns of the surrounding watershed, in violation of the HOA's Environmental Covenant. The structure must be removed and the watershed restored to its natural drainage condition within 30 days. A fine of $500 per day will accrue from the date of this notice until the violation is remedied. Emmett had read the notice at his desk on the morning it arrived and had set it on the engineering log beside his coffee. He had read Section 7.4 of the Ridgeline Hollow CC&Rs. He had pulled the CC&Rs from the county clerk's recorded document portal the week after he purchased his parcel, standard practice for any property adjacent to an HOA development. The same professional diligence that had sent him to the county engineer's stormwater files before his purchase offer. Section 7.4 read, "No owner within the Ridgeline Hollow community shall construct, install, or permit any structure or modification that materially alters the natural drainage patterns of the surrounding watershed without prior written approval of the Architectural Review Committee." He had read the covenant's operative phrase, "No owner within the Ridgeline Hollow community." He had pulled his county assessor's parcel map and had confirmed what he already knew from his pre-purchase research. His 520-acre parcel was not within the Ridgeline Hollow community. It was not within the HOA's geographic boundary. It was not subject to the HOA's CC&Rs. The HOA's geographic boundary, the line defining the extent of the community's recorded covenants, ran along the southern bank of Crestfall Creek at a point approximately 600 feet downstream of his dam. His parcel was upstream. It had never been platted as part of the Ridgeline Hollow subdivision. It had never been subjected to the Ridgeline Hollow CC&Rs by any recorded instrument. The CC&Rs had been recorded against the 110 lots within the Ridgeline Hollow plat. His 520-acre parcel was not one of them. He had written in his engineering log, RH violation notice received January 3, 2023. Cites CC&R. Section 7.4, Environmental Covenant. Legal defect. Section 7.4 applies to owners within the Ridgeline Hollow community. My parcel is outside RH geographic boundary by 600 feet. C, and Rs not recorded against my parcel. HOA has no jurisdiction. Notice is void. Fine accrual is void. Document and retain. He had called his law partner that afternoon. His law partner was a woman named Ruth Alcott, admitted to the bar in 1988, 14 years of HOA and property law practice, the partner who handled the legal proceedings that Emmett's engineering work produced, and the engineering analysis that Ruth's legal work required. They had been partners for 18 years, their practice built on the intersection of engineering and law that Emmett had identified as the most consequential space in water rights work. Ruth had handled the legal dimension of 6 of Emmett's 11 dam projects, had drafted the water rights instruments for 4 reservoir operating agreements, and had appeared in 3 state dam safety proceedings as Emmett's legal counsel. He had briefed her in 20 minutes. The violation notice, Section 7.4's operative language, the HOA's geographic boundary, the 600-foot gap, the absence of any recorded covenant against his parcel, the DOL-2022-041 sole operator authority provision. He had said, "The fine is void. Every subsequent fine will be void. The HOA is acting beyond its jurisdictional authority." Ruth had said, "Ultra vires. The action is beyond their legal power. Send me the notice, the C, and Rs, and the parcel map with the HOA's boundary marked. I'll confirm the jurisdictional analysis and prepare the response." He had sent everything that evening. She had called the next morning and had confirmed his analysis without qualification. The C, and Rs geographic scope was limited to owners within the Ridgeline Hollow community. The community's boundaries were defined by the recorded subdivision plat. His parcel was outside those boundaries, and the HOA had no authority to enforce Section 7.4 against a structure on his property. She had said, "I can send a response letter now that will put the HOA on notice of the jurisdictional defect. If they continue to issue fines after receiving notice that the enforcement action is void, every subsequent fine becomes an aggravating factor in the declaratory judgment action." He had said, "Let them issue the fines. I want the full record of a void enforcement action before we file. Document every notice, confirm the jurisdictional defect in writing to them after the third notice so they can't claim ignorance, and then file when we have 6 months of documented ultra vires enforcement." Ruth had said, "You want to let $70,000 accumulate." He had said, "I want the record to show 6 months of an HOA fining a licensed dam operator for a licensed structure on private property outside their jurisdiction, after receiving written notice that the action was void. That record is worth more in a declaratory judgment proceeding than a quick response letter that stops the fines at $1,500. Ruth had said, "Your call. I'll document each notice as it arrives and prepare the written notice of jurisdictional defect for delivery after the third citation." The Violation Committee had issued its second notice on February 7, 2023. 35 days after the first notice, the 30-day cure period elapsed without Emmett taking any action to remove the dam, the fine now accruing at $500 per day. The second notice had added a structural complaint. The dam's construction had altered the creek's flow regime and created standing water upstream of the HOA's boundary that constituted an environmental nuisance under Section 7.4's extended provisions. The fine balance noted on the second notice, $17,500, 35 days at $500 per day. Ruth had received the second notice from Emmett and had added it to the enforcement file with a notation. Notice 2. February 7, 2023. Same jurisdictional defect. Fine balance, $17,500. Void. Dam operating license, DOL-2022-041. Issued December 19, 2022. Structure is state licensed. HOA citing a state licensed structure on private property outside their jurisdiction. File. The third notice had arrived on March 8, 2023, 29 days after the second, the fine balance now showing $32,000. The third notice had added a new element. The HOA's environmental covenant chair had driven to the county road closest to Emmett's Dam and had taken photographs of the reservoir from the road right-of-way, including the photographs with the notice as exhibits. The photographs showed the 34-acre reservoir at operating pool, the water surface extending upstream from the dam's crest, the Morning Glory Spillway's inlet ring visible at the water's surface, the earthen embankment clean and grassed from the fall's construction. The notice had described the reservoir as an industrial-scale water impoundment inconsistent with the rural character of the surrounding watershed and materially damaging to the environmental integrity the HOA's covenants were designed to protect. Ruth had read the third notice and had said, "They've added photographs and a character description. They're building an aesthetic argument. Send the jurisdictional notice now. After the third citation, they cannot claim they were unaware of the defect." She had sent the jurisdictional notice on March 10, 2023, a 4-page letter on the law firm's letterhead, addressed to Garrison Webb as HOA president and to the HOA's registered agent. The letter's analysis was precise. Section 7.4's operative language, No owner within the Ridgeline Hollow community. Define the covenant's geographic scope as the Ridgeline Hollow subdivision plat. Emmett's 520-acre parcel was outside that plat. No recorded instrument subjected Emmett's parcel to the Ridgeline Hollow CC and RS. The HOA's enforcement action was ultra-virus, beyond the HOA's legal authority, and every fine issued to date was void and unenforceable. The letter had included as exhibits the CC and R text, the Ridgeline Hollow plat boundary diagram, the county assessor's parcel map showing the 600-foot gap between the HOA's boundary and Emmett's parcel, and the first page of DOL-2022-041, establishing the state's licensing jurisdiction over the structure. The letter had concluded, Mr. Cross requests that the HOA rescind all violation notices and fine assessments issued to date, acknowledge in writing the HOA's jurisdictional limits and their inapplicability to Mr. Cross's property, and cease further enforcement action against Mr. Cross or his property. Continued enforcement action following receipt of this notice will be treated as willful ultra-virus conduct in any subsequent declaratory judgment proceeding. Garrison had received the letter on March 12th and had called the HOA's property counsel, a general practice attorney named David Morse, whose HOA work had previously consisted of collections actions and CC and R amendment filings, with no prior experience in dam safety law or jurisdictional boundary disputes. Morse had read Ruth's letter and had told Garrison, "The jurisdictional argument is serious. Section 7.4's language does limit the covenant to owners within the community. I need to look at whether there's a broader reading of the covenant or an alternative legal theory before I advise you on how to respond." Garrison had said, "They built a dam on our watershed. It's ugly, it's industrial, and it doesn't belong there. I don't care what their letter says. Keep issuing notices." Morse had said, "Garrison, if the jurisdictional analysis is correct," Garrison had said, "find a theory that makes it wrong." The fourth notice had arrived on April 10th, 2023, 1 month after Ruth's jurisdictional notice, the fine balance now showing $48,500. The fourth notice had cited a new provision, Section 9.2 of the CC and Rs, the General Nuisance Covenant, which prohibited any condition on or adjacent to Ridgeline Hollow properties that creates a nuisance affecting the health, safety, or aesthetic character of the community. The addition of Section 9.2 had been Morse's attempt at the alternative theory Garrison had requested, the argument that even if Section 7.4's geographic scope was limited to owners within the community, Section 9.2's reference to conditions adjacent to Ridgeline Hollow properties extended the HOA's enforcement authority to neighboring properties. Ruth had read Section 9.2 and had called Emmett immediately. She had said, "They've added Section 9.2, adjacent property nuisance. The theory fails for the same reason Section 7.4 fails. The CC and Rs are recorded instruments. Their geographic scope is determined by the recording, and recorded covenants bind only the parcels against which they are recorded." Section 9.2's reference to adjacent to describes the condition's location relative to HOA properties. It does not extend the covenant's binding force to non-HOA parcels. An HOA covenant cannot be enforced against a property that was never subjected to the covenant by a recorded instrument. Morse knows this, or should know it. Emmett had said, he knows it. Garrison told him to find a theory anyway. The fifth notice had arrived on May 9th, 2023. The sixth had arrived on June 6th, 2023. Each had cited both Section 7.4 and Section 9.2. Each had added 1 month of fine accrual, and the sixth notice's fine balance had shown $70,000, the number that had accumulated across 6 months of void enforcement at $500 per day from the January 3rd notice date, interrupted briefly by a week in February, when the committee had paused to consider Ruth's anticipated response before deciding Garrison's directive superseded the jurisdictional concern. Emmett had received the sixth notice on a Tuesday morning in June and had read the fine balance, $70,000, bold type at the top of the notice's third page, with the equanimity of a man who had known from the first notice that the number was void and had documented each increment of its accumulation specifically to present it to a court. He had set the notice in the enforcement file beside the previous 5 and had called Ruth. He had said, 6 months, $70,000. They received written notice of the jurisdictional defect after the 3rd citation and continued for 3 more months. File the declaratory judgment action. Ruth had said, I'll file Monday. And the outlet works. You want to include the adjustment in the demand letter before we file, or hold it as a post-filing action? He had thought about the 2004 stormwater plan in the county engineer's files, the Ridgeline Hollow Development's drainage system, designed around the upstream watershed's natural impoundment capacity, the detention pond, sized below what a direct discharge watershed required, the design gap filled by the upstream impoundment assumption. He had thought about what a 40% reduction in Cross Pond's operating pool would do to Crestfall Creek's base flow during a significant rain event, the reduced attenuation, the increased peak flow arriving at the detention pond faster and higher than the 2004 design had anticipated, the standing water that would appear at the development's 3 low-point drainage structures within 14 days of the reduction if the June precipitation patterns continued. He had said, included in the demand letter, I want them to understand what the Outlet Works Authority means before they read the declaratory judgment complaint. Ruth had prepared the demand letter over the weekend and had sent it certified mail on Monday morning, concurrent with filing the declaratory judgment complaint in County District Court. The letter was 11 pages. The first 4 pages had set out the jurisdictional analysis, Section 7.4's geographic scope, the HOA's plat boundary, the 600-foot gap, the absence of any recorded covenant against Emmett's parcel, the ultra vires character of every fine issued. The 5th page had addressed the drainage dependency, the 2004 stormwater management plan, the design assumption of upstream impoundment capacity, the specific consequence of Cross Pond's construction for the development's drainage performance. Cross Pond's 210 acre-foot reservoir has increased the upstream impoundment capacity available to attenuate Crestfall Creek's peak flows beyond the natural impoundment capacity assumed in the 2004 Stormwater Management Plan. The Ridgeline Hollow Development's drainage infrastructure performs better with Cross Pond in operation than without it. The HOA has spent 6 months attempting to find the licensed operator of a structure that improves the performance of the development's own drainage system. The 6th page had addressed DOL-2022-041, the license, the sole operator authority provision, the State Dam Safety Office's exclusive jurisdiction over the structure. The 7th through 10th pages had set out the demand. Rescind all 6 violation notices. Void the $70,000 fine balance, issue a written acknowledgement of the HOA's jurisdictional limits and their inapplicability to Emmett's property, and pay Emmett's legal costs for 6 months of responding to void enforcement action. The 11th page had contained 1 paragraph that Ruth had drafted and Emmett had read twice before approving. Mr. Cross holds dam operating license, DOL-2022-041, which grants him exclusive authority over the operation of Cross Pond's outlet works. That authority includes the adjustment of the dam's outlet works to any level within the reservoir's design operating range. Mr. Cross has not exercised that authority to date. If the HOA does not rescind the void enforcement action and acknowledge the jurisdictional limits within 30 days, Mr. Cross will exercise his licensed operator authority to adjust Cross Pond's outlet works to reduce the reservoir to 60% of its normal operating pool. The consequences of that adjustment for Crestfall Creek's base flow and the Ridgeline Hollow Development's stormwater management system are documented in the county engineer's 2004 Stormwater Management Plan, which is a public record available at the county engineer's office. The demand letter had been delivered on a Monday. The declaratory judgment complaint had been filed the same morning. The HOA had 30 days to respond. Emmett had gone to the dam that evening. The June dusk warm on the ridge, the reservoir at its full 18-foot operating pool, the Morning Glory spillway running its thin overflow arc at the pool's surface, Crestfall Creek moving downstream through the bedrock crossing channel below the outlet works. 600 feet downstream, the Ridgeline Hollow development sat in the evening light, its streets dry, its detention pond at its normal operating level, its drainage system performing at the parameters the 2004 plan had designed. Parameters that assumed the upstream impoundment capacity cross pond had just increased by 210 acre-feet. He had read the staff gauge at the dam's upstream face, 18.0 feet, normal operating pool. He had written in his engineering log, June 12, 2023, reservoir, 18.0 feet, normal operating pool. Demand letter delivered. Declaratory judgment filed. 6 violation notices. $70,000 void fines. Outlet works. Nominal. 30-day response window open. Matter. Filed. He had looked at the outlet works. The Morning Glory spillway, the outlet pipe, the hand wheel on the outlet gate assembly at the downstream face, his license, his gate, his reservoir. The water did what you told it to do if you asked correctly. He had been asking correctly for 40 years. He went inside. Ruth had pulled DOL-2022-041 from the State Dam Safety Office's public license portal, the morning after the demand letter went out. Standard practice, the license document filed in the case folder as the foundational exhibit for the declaratory judgment complaint, the instrument that made every other legal question in the proceeding secondary to the one the license answered first. The license was 7 pages. Ruth had read all 7 with the specific attention of a property and water rights attorney, reading an instrument she intended to present to a judge who had probably never seen a dam operating license and would need to understand its legal significance from her presentation, rather than from prior familiarity. She had annotated the margins in 3 colors: black for the factual provisions, red for the jurisdictional provisions, blue for the provisions that directly contradicted the HOA's enforcement theory. The first page, the license's parties and subject matter. Licensed operator, Emmett Cross, PEJD. Structure, Cross Pond Dam, a Class B earthen impoundment on Crestfall Creek, located on the Cross property, parcel number 44-7821-003, County Deed Records. Issuing authority, State Dam Safety Office, Division of Water Resources. License number, DOL-2022-041. Issue date, December 19, 2022. She had annotated in red. State licensing jurisdiction established. Structure on private parcel outside HOA boundary. HOA has no regulatory authority. The second page, the operational conditions. Normal operating pool, 18 feet above outlet works invert. Mandatory inspection schedule, 10-year intervals, with interim inspections triggered by seismic events exceeding magnitude 4.5 or precipitation events exceeding the 100-year storm. Maintenance log requirements, annual entries, available to the Dam Safety Office on request. She had annotated in black. Operational conditions. Emmett's compliance is current and documented. The third page, the sole operator authority provision. Ruth had read it 3 times and had annotated it in all 3 colors. The provision read, the licensed operator named in this license has exclusive authority over the operation of this dam's outlet works, spillway structures, and all appurtenant hydraulic control infrastructure. The exercise of that authority is subject only to the directives of the State Dam Safety Office, issued pursuant to the state's dam safety statute. No court of general jurisdiction, no local governmental body, no homeowners association, no private party, and no governmental entity other than the State Dam Safety Office may direct, compel, or prohibit the licensed operator's exercise of operational authority without the prior written concurrence of the State Dam Safety Office. Any order, directive, or demand purporting to compel or prohibit the licensed operator's operational decisions without the State Dam Safety Office's written concurrence is void and without legal effect. She had starred that paragraph in red and had written in the margin, HOA's removal demand equals void. County court removal order without DSO concurrence equals void. This provision preempts the entire HOA enforcement theory. The fourth page, the downstream hazard assessment summary. The license's incorporation of the downstream hazard assessment findings, the Class B classification basis, the spillway design standard, the downstream development's identification as the basis for the hazard classification. She had annotated in blue, DSO reviewed downstream development as part of license process. State was aware of Ridgeline Hollow at licensing. License issued with full knowledge of downstream residential use. Pages 5 through 7. The construction compliance findings, the inspector's certification, and the license's legal authority citations. Ruth had read the legal authority citations with particular attention. The state dam safety statute sections under which the license had been issued, the regulatory framework that placed Class B dam licensing within the exclusive jurisdiction of the State Dam Safety Office, and the preemption provision of the dam safety statute that explicitly superseded local governmental authority over licensed dam structures. She had called Emmett after finishing the annotation and had said, "The license is better than I expected. The sole operator authority provision names homeowners associations specifically, not just courts and governmental bodies, but homeowners associations. The drafters of this provision either anticipated this exact situation or encountered it previously. Either way, the HOA's name is in the preemption language." Emmett had said, "The state revised the standard license language in 2019 after an HOA in the Southern District attempted to fine a licensed dam operator for aesthetic violations. The revision added homeowners associations to the list of excluded authorities specifically because of that case." Ruth had said, "You knew this when you applied for the license." He had said, "I knew it when I read the 2019 revision notice in the Dam Safety Office's regulatory bulletin. I noted it in my project file before I submitted the permit application." She had been quiet for a moment. Then she had said, "You documented the HOA's inability to fine you before you built the dam." He had said, "I documented the legal framework that would govern any dispute about the dam before I built the dam. That's what a 40-year engineering and law practice produces. The framework was in the regulatory bulletin. I read the bulletin, I filed the note, I built the dam." Ruth had added the 2019 regulatory revision notice to the declaratory judgment file behind the license document and had written the case theory memo that afternoon. DOL-2022-041 preempted the HOA's enforcement authority by express statutory and license provision. The HOA's CC and R geographic scope excluded Emmett's parcel. The fine enforcement was ultra-virus on two independent grounds. The drainage dependency made the HOA's enforcement action structurally irrational, and the demand letter's outlet works paragraph gave the HOA 30 days to acknowledge the legal reality before the physical reality became visible in their streets. Garrison had received the demand letter and the declaratory judgment complaint on the same Tuesday morning. The demand letter by certified mail, the complaint by process server, the two documents arriving within 20 minutes of each other at the HOA's management company office. The management company had forwarded both to Garrison by email at 11 a.m. with a note, "This appears to require immediate legal attention." Garrison had read the demand letter first. He had read Section 7.4's operative language argument, the jurisdictional boundary analysis, the 600-foot gap documentation, the drainage dependency paragraph, and the outlet works warning in sequence, his reaction moving through the registers of a man who had organized an enforcement system he believed was legally sound, and was now reading a letter that described that system as void from its first notice. He had stopped reading at the outlet works paragraph and had read it again. He had called Morse immediately. Morse had already received the complaint from the process server and had been reading it when Garrison called. He had said, "I need a day to review everything before we talk. Call me tomorrow morning." Garrison had called the following morning at 8 a.m. Morse had said, "The jurisdictional argument is strong. Section 7.4's language is a problem. The geographic scope limitation is real, and Ruth Alcott's analysis of it is correct. The Section 9.2 adjacent property theory is weaker than I'd hoped when I added it to the fourth notice. I'm not going to tell you the HOA wins on the jurisdictional question, because I don't think we do." Garrison had said, "What about the environmental character argument? The dam altered the watershed. That has to be actionable, regardless of where the property line is." Morse had said, "The environmental character argument is the public policy version of the Section 9.2 theory. It has rhetorical force, and it doesn't have legal force. An HOA covenant is a recorded instrument. Its enforcement authority is bounded by its recording. You cannot enforce a recorded covenant against a property that was never subjected to it. Garrison had said, "The dam is ugly. It changed the creek. It changed the view from the southern lots. Our residents bought their homes in a natural watershed setting, and now there's an industrial dam upstream. That has to count for something." Morse had said, "It counts for something in a community meeting. It doesn't count for much in a declaratory judgment proceeding against a licensed civil engineer, who is also a water rights attorney and who documented the legal framework before he built the dam." Garrison had said, "The removal order. We counterclaim for removal." Morse had said, Garrison had said, "File the counterclaim. The dam is on our watershed. A county court can order it removed." Morse had said, "The dam operating license's sole operator authority provision says otherwise. The license specifically names homeowners associations as excluded from the authority to compel or prohibit the licensed operator's operational decisions. A removal order compels an operational decision. It is exactly the category of directive the license provision addresses. And the Dam Safety Statute's preemption provision supersedes local court orders affecting licensed structures without the state dam safety office's concurrence." Garrison had said, "File the counterclaim. Let the court decide." Morse had said, "I want to note for the record that I advised against the counterclaim on the grounds I've described." Garrison had said, "Noted. File it." The board meeting had been on a Wednesday evening. All 5 members, Morse on the phone, 44 residents in attendance, the largest board meeting turnout in the HOA's history. Morse had presented the legal situation with the careful phrasing of an attorney whose client had overruled his advice and who was managing the gap between his professional assessment and his client's instructions. He had described the HOA's position as contested but defensible, the jurisdictional question as a matter for the court to resolve, and the counterclaim for removal as the board's assertion of the community's right to a natural watershed environment free from unauthorized industrial structures. A resident named Patricia Vance, Unit 22, a retired landscape architect whose southern-facing lot had the clearest view of the reservoir's water surface from her back deck, had raised her hand and had said, "The demand letter's drainage paragraph. It says our stormwater system was designed around the upstream impoundment capacity and that the dam improves our drainage. Is that true?" Morse had said, "The county engineer's records contain a 2004 stormwater management plan that includes language about upstream impoundment capacity. The HOA's position is that the 2004 plan's design assumptions do not create a legal right for an upstream property owner to build a dam affecting our watershed." Patricia Vance had said, "I didn't ask about legal rights. I asked whether it was true that our drainage depends on the upstream impoundment." Morse had been quiet for a moment. He had said, "The 2004 plan's design assumptions suggest that the upstream watershed's natural impoundment capacity was a factor in the detention pond's sizing." Patricia Vance had written something in her notepad and had said, "So we are finding the person whose dam helps drain our neighborhood." Garrison had said, "The dam was built without our approval, and it affects our watershed and our community's environmental character. The board has voted to pursue the removal order, and we are moving forward." The vote had been 5-0. The same vote, the same margin, the same institutional confidence that had produced the first violation notice 7 months earlier. The board had directed Morse to file the counterclaim and to pursue the removal order in the declaratory judgment proceeding. The community meeting had followed 4 days later, all 110 units notified, the clubhouse at capacity, Garrison at the front with the composure of a president who had prepared extensively for a meeting he intended to control. He had described Emmett's Dam as an unauthorized industrial structure built upstream of their community without the HOA's knowledge or approval, a structure that had changed the character of the watershed their residents had purchased homes to live beside, and a structure that the HOA was legally entitled to have removed. He had said, "We did not approve this dam. We were not consulted. A dam is not a fence or a shed. It is a permanent industrial alteration of a natural waterway. And the covenant that protects our community's environmental character applies to exactly this kind of structure. We have filed our counterclaim. We will get the removal order. The dam will come down." Patricia Vance had raised her hand from the 3rd row and had said, "What happens to our drainage if the dam comes down?" Garrison had said, "Our drainage system was designed for natural watershed conditions and will function as designed." Patricia Vance had said, "The 2004 plan assumed upstream impoundment capacity." Garrison had said, "The 2004 plan was designed for this watershed, and our drainage system works." Patricia Vance had said, "That's not an answer." Garrison had looked at Morse, who was in the back of the room. Morse had looked at the floor. Emmett had read the community meeting summary in the county paper the following morning. Ridgeline Hollow, HOA vows to fight upstream dam, seeks removal order. At his desk with his engineering log open beside his coffee. He had read Garrison's quote about the removal order and the dam coming down. He had set the paper down and had called Ruth. He had said, "The meeting summary is in the paper. Garrison told 110 households the dam will come down." Ruth had said, "I read it this morning." He had said, "Counterclaim filed?" She had said, "Filed yesterday. Removal of Cross Pond Dam is a violation of the HOA's CC&R environmental covenant. Injunctive relief compelling Emmett to cease dam operations pending removal." Morse filed both claims. Emmett had said, "The State Dam Safety Office needs to be notified of the removal claim. Standard practice when a licensed structure is the subject of a court removal demand. The office should be aware that a party is seeking a court order affecting a licensed dam." Ruth had said, "I'll notify the office today. They'll want to review the removal claim and the license provisions." And Emmett, "The outlet works. The 30-day demand window closes in 3 weeks. Garrison's board voted 5-0 to reject the demand and pursue removal. The outlet works adjustment becomes available in 3 weeks." He had said, "I know. Let the counterclaim develop in the court record first. I want the removal claim in the file before the outlet adjustment goes in. The sequence matters. The HOA seeks removal. The state's position preempts the removal order. And then the outlet adjustment demonstrates what the license's operational authority actually means in physical terms." Ruth had said, "I'll prepare the state notification this afternoon and file the declaratory judgment answer to the counterclaim tomorrow." He had gone to the dam that evening and had stood on the crest. The June evening warm, the reservoir at 18 feet, the Morning Glory spillway running its overflow, Crestfall Creek moving downstream. 600 feet south, the Ridgeline Hollow development sat in the evening light. A board of 5 had voted to remove the structure he was standing on. A licensed attorney who had told them not to file the counterclaim had filed it anyway. A president who had said the dam was ugly had told 110 households it would come down. He had looked at the outlet works handwheel at the downstream face, the gate sealed at the outlet pipe's full closed position, the reservoir at operating pool, the downstream channel running at its normal late June base flow, his license, his gate, his reservoir. He had written in his engineering log, June 19, 2023, counterclaim filed, removal demand in court record, Ruth notifying DSO of removal claim, outlet works, nominal, 18.0 feet, 30-day demand window, 3 weeks remaining, sequence, DSO notification, state position, outlet adjustment. The dam will not come down. The license says so. He had closed the log. The water did what you told it to do if you asked correctly. He went inside. The show cause order had arrived in Ruth's office by fax on a Tuesday morning. 7 pages from the county district court's clerk. The caption reading, Ridgeline Hollow HOA versus Cross. Case number CV-2023-0847. Order to show cause. Preliminary injunction and dam removal. The order had been issued by Judge Harold Fenn, a county district judge whose docket ran primarily to contract disputes, landlord-tenant matters, and small business litigation, whose experience with water law was limited to 2 irrigation ditch disputes in his 12 years on the bench, and who had read Morse's counterclaim for removal and had found it sufficiently supported on its face to warrant a show cause order, requiring Emmett to appear and demonstrate why a preliminary injunction compelling dam removal should not be issued pending the full proceedings resolution. The order had set the show cause hearing for 21 days out, and had included a temporary restraining order prohibiting Emmett from making any modifications to the dam structure or outlet works pending the hearing. Ruth had read the temporary restraining order paragraph and had called Emmett immediately. She had said, Fenn issued a show cause order and a TRO. The TRO purports to prohibit modifications to the dam structure or outlet works pending the hearing. Emmett had said, "The TRO is void. DOL-2022-041's sole operator authority provision supersedes a county court's operational directive without the dam safety office's written concurrence." Fenn doesn't know he issued a void order, but he did. Ruth had said, "I know. The notification to the dam safety office needs to go today, before the hearing date, before any further court action. The office needs to be in the record as having been notified before Fenn takes any further steps." He had said, "Call the district director's office now. I'll send the license documentation by email while you're on the phone." Ruth had called the state dam safety office's district director, a licensed engineer named Howard Pell, whose district covered the county's northern watershed, and who had supervised the DOL-2022-041 issuance and construction inspection. She had briefed him in 10 minutes, the HOA's counterclaim, the show cause order, the TRO, Fenn's apparent unfamiliarity with dam safety preemption law. Pell had said, before she finished the briefing, "The county court cannot order removal of a licensed dam without this office's written concurrence. That's in the statute and in the license. I'll have our legal counsel prepare a formal notification to the court by end of week." He had said it with the flat authority of a regulatory official who had dealt with jurisdictional overreach before, the specific tone of an agency director who knew his office's statutory authority and did not require argument to exercise it. The dam safety office's formal notification had been filed with the county district court on Friday of the same week, 4 days after Ruth's call, 3 pages signed by the office's district legal counsel. The notification was direct. Dam operating license, DOL-2022-041, was a valid Class B operating license issued under the state dam safety statute. The statute's preemption provision, Section 34-217, prohibited any court of general jurisdiction from ordering the removal, modification, or operational cessation of a licensed dam structure without the prior written concurrence of the state dam safety office. The office had not concurred in any removal order affecting DOL-2022-041. The show cause order and the temporary restraining order issued by the county district court were therefore void as against the licensed operator's operational authority. The office requested that the court stay all proceedings affecting the dam's operational status, pending a scheduling conference with the office's legal counsel and the parties. Judge Fenn had received the notification on Friday afternoon, read it over the weekend, and had issued a stay order on Monday morning. The show cause hearing postponed indefinitely, the TRO's operational provisions suspended pending the scheduling conference. The court's order noting, "The court has received a filing from the State Dam Safety Office advising that proceedings affecting a licensed dam structure require the office's concurrence under state statute. The court will schedule a conference with all parties and the office's legal counsel to clarify the applicable jurisdictional framework before proceeding further." Ruth had called Emmett with the stay order at 8:30 a.m. Monday. She had said, "Fenn stayed everything. The show cause hearing is postponed. The TRO's operational provisions are suspended." The Dam Safety Office's notification worked in 4 business days. Emmett had said, "Faster than I expected. Pell's office moves quickly when a county court steps on their jurisdiction." Ruth had said, "The scheduling conference will be the moment the office's legal counsel explains dam safety preemption to Fenn in person. After that conference, the removal counterclaim is effectively over. Fenn will understand that he cannot order removal without the office's concurrence, and the office will not concur in removal of a properly constructed and licensed Class B dam." He had said, "The outlet works." She had said, "The TRO's operational provisions are suspended. You have your licensed operator authority back." The 30-day demand window closed last week with no response from the HOA. The outlet adjustment is available. He had said, "I'll go to the dam this afternoon." She had said, "Document everything. Staff gauge before and after, outlet position photographs, daily gauge readings. If the drainage effects appear in the development within 14 days, I want the photographic record of when and where they appeared." He had gone to the dam at 2 p.m. on a Monday. The late June afternoon warm and dry. The reservoir at 18.0 feet on the staff gauge. The Morning Glory spillway running at standard overflow. Crestfall Creek at its normal June base flow in the downstream channel. He had read the staff gauge, photographed the gauge and the gate assembly and the reservoir surface, and noted the readings in his engineering log. He had then gone to the outlet works at the dam's downstream face. The outlet works consisted of a 24-inch diameter, reinforced concrete pipe running through the dam's base from the inlet structure at the reservoir's upstream face to the outlet portal at the downstream face, controlled by a slide gate at the outlet portal, operated by a hand wheel mounted on the downstream face's concrete control pad. The gate had been fabricated to Emmett's specifications, a full-bore slide gate capable of varying the outlet flow from 0 to maximum conduit capacity. The hand wheel calibrated to a gate opening scale marked in tenths, from fully closed to fully open. At fully closed, the gate sealed against the outlet pipe's face, no flow. At fully open, the gate retracted entirely, the full 24-inch pipe diameter available for flow. The normal operating position was fully closed. At normal pool, the Morning Glory spillway handled all outflow above the operating pool elevation, and the outlet gate was kept sealed except during maintenance drawdowns. Emmett had calculated the outlet opening required to achieve 60% of the normal operating pool over a 14-day drawdown period, assuming the current inflow from Crestfall Creek's June base flow. The calculation was straightforward. The reservoir's volume at 60% of the 18-foot pool was approximately 126 acre-feet. The current volume at 18 feet was approximately 210 acre-feet. The drawdown required was 84 acre-feet over 14 days. He had set the outlet gate opening at the position his calculation required. 1/4 open. The gate retracted 4 inches from fully closed. The outlet flow rate sufficient to achieve the target drawdown on the calculated schedule. He had photographed the gate opening position, confirmed the outlet flow appearing in the downstream channel as a steady discharge, and noted the time in his engineering log. 2:47 p.m., Monday, June 26, 2023. Outlet gate, 1/4 open. Estimated flow rate, 6.2 cubic feet per second. Reservoir drawdown commences. Target, 60% of operating pool, 10.8 feet, in 14 days. Downstream flow, confirmed. He had returned to the dam each morning at 6 a.m. to read the staff gauge, photograph the gauge and the outlet works, and note the reservoir level in his engineering log. Day 1, 17.6 feet, 4/10 below normal pool, downstream channel running at elevated base flow. The outlet's 6.2 cubic feet per second discharge added to Crestfall Creek's natural flow, the increase modest, the downstream channel handling it within its normal cross-section. Day 3, 16.8 feet, 14 inches below normal pool. Emmett had driven to the county road closest to the Ridgeline Hollow development's southern boundary on Day 3, the road that provided the closest public vantage point to the development's detention pond, and had observed the detention pond through the boundary fence with his telephoto lens. The pond was at its normal operating level, the water surface 4.2 feet below the overflow weir elevation, within its standard late June range. He had noted the observation in his field notebook and had photographed the pond from the road. Day 5, 15.9 feet, 25 inches below normal pool. The outlet was running steadily, the drawdown tracking his calculation. He had checked the National Weather Service forecast. A significant precipitation event was developing in the regional weather pattern, a slow-moving low-pressure system expected to produce 2 to 3 inches of rainfall over the watershed in the period between Day 7 and Day 10. He had written in his engineering log, Day 5, June 30th, reservoir, 15.9 feet, precipitation event forecast, 2 to 3 inches, days 7 to 10. Timing is significant. Reduced upstream storage capacity will limit peak flow attenuation during event. Downstream drainage system will experience elevated inflow relative to 2004 design parameters. Document detention pond response. The precipitation event had arrived on Day 7, a 2-day rain beginning on a Wednesday evening and continuing through Thursday, the watershed receiving 2.1 inches of precipitation over 36 hours, the majority falling in a 12-hour period on Thursday. Emmett had been at his engineering office during the rain, monitoring the staff gauge remotely through the water level sensor he had installed at the dam's upstream face. The sensor transmitting gauge readings every 15 minutes to his office laptop, the data logging automatically to his engineering log file. The reservoir had risen 1.4 feet during the precipitation event, the reduced storage capacity accepting the event's runoff and rising faster than it would have at full pool. The Morning Glory spillway handling the overflow, the reservoir peaking at 16.1 feet on Thursday afternoon, before beginning to recede as inflow slowed. At full pool, the same event would have produced a 0.6-foot reservoir rise, the additional 150 acre-feet of storage buffer absorbing the difference. The 84 acre-feet of storage he had removed from the reservoir by the outlet drawdown had been directly reflected in the increased rise rate during the event. He had driven to the county road at the development's southern boundary at 4 p.m. Thursday, the rain still light, the afternoon gray and wet, and had observed the detention pond and the development's street network through the telephoto lens. The detention pond's water surface was 1.8 feet below the overflow weir, 2.4 feet higher than its Day 3 observation level, the pond having received the same precipitation event's direct contribution and the elevated discharge from Crestfall Creek at the reduced attenuation rate. The pond was still within its operating range, but its freeboard had dropped from 4.2 feet to 1.8 feet in 7 days. The development's 3 low-point drainage structures, locations he had identified from the county engineer's grading plan for the subdivision, accessible from the county road at 2 points, and from a public trail easement at the third, showed standing water. The first low point, at the intersection of Ridgeline Drive and Hollow Court, had water standing approximately 4 inches deep across a 30-foot diameter area of the street surface, the storm inlet at the low point's center visibly submerged under the standing water. The second low point, at the turnaround at the development's southwestern cul-de-sac, had water standing 6 inches deep across the cul-de-sac's low arc, a car parked in the cul-de-sac's outer ring sitting with water at its door sill. The third low point, visible from the public trail easement at the development's southeastern corner, had water standing at the trail's crossing with the development's pedestrian path, a shallow sheet of water extending across both the path and the adjacent lawn area. He had photographed all 3 low points through the telephoto lens, the images dated and time-stamped, and had noted the observations in his field notebook. Day 8, July 4th. Detention pond, 1.8 feet below OFW. Freeboard reduced 2.4 feet in 7 days. LP1, Ridgeline/Hollow Court. Standing water, estimated 4 inches, 30 feet diameter, inlet submerged. LP2, SW cul-de-sac. Standing water, estimated 6 inches, vehicle in water. LP3, SE corner trail. Sheet flow across path and lawn. Drainage system showing stress consistent with reduced upstream storage capacity. 2004 design parameters exceeded at 3 locations. He had gone back to his office and had added the field observations to the engineering log file, with the Day 7 through Day 8 reservoir data. The drainage dependency was no longer in the 2004 Stormwater Plan's design assumptions section. It was in standing water at 3 locations in the development that had been dry every day Cross Pond had been at operating pool. Day 10, 13.1 feet. The reservoir was approaching the target 60% level. 10.8 feet was the target, 2 more days at the current discharge rate. He had continued his daily gauge readings and his periodic documentation of the development's drainage conditions. Day 11. The development's community forum had posts from 4 residents about the standing water at the cul-de-sac and the Ridgeline Drive intersection. Photographs taken from within the development, the standing water visible, the posts asking whether the HOA's drainage system needed maintenance. Garrison had replied, "The drainage system is functioning normally. The standing water is a result of the precipitation event and will recede as the ground dries." Patricia Vance had replied to Garrison's post with a single question. "Has anyone checked the upstream reservoir level recently?" Garrison had called Emmett on day 12. The call coming at 11 a.m., the reservoir at 12.4 feet, the detention pond's freeboard at 1.2 feet, the standing water at the low point still present 4 days after the precipitation event. He had said, "Mr. Cross, this is Garrison Webb. I want to talk about the reservoir." Emmett had said, "The reservoir is at 12.4 feet. That's 60% of normal operating pool. I exercised my licensed operator authority to adjust the outlet works on June 26th. The adjustment is within the operational parameters of DOL-2022-041. Garrison had said, "Your adjustment is what caused the flooding in our neighborhood." Emmett had said, "The standing water in your neighborhood is the result of your detention system's reduced upstream storage attenuation during a precipitation event. The 2004 Stormwater Management Plan assumed upstream impoundment capacity that I have partially reduced by exercising my licensed operator authority. The plan is in the county engineer's files. The design assumption is on page 14. I read it in December 2021. Garrison had been quiet for a moment. Then he had said, "You're doing this deliberately. You're holding our drainage hostage." Emmett had said, "I'm a licensed dam operator exercising my operational authority under DOL-2022-041. Your board received a demand letter in June that offered to resolve this matter through a recorded drainage easement and dam maintenance agreement. Your board rejected that demand and filed a counterclaim seeking removal of my dam. The outlet adjustment is the physical consequence of your board's decision to reject the demand and pursue removal rather than negotiate the recorded instrument. The outlet stays at 60% until there's a recorded easement in the county deed records or until the court resolves the declaratory judgment action." Garrison had said, "The court stay." Emmett had said, "The show cause order is stayed pending the Dam Safety Office's scheduling conference. The TRO's operational provisions were suspended in the stay order. I have my licensed operator authority and I am exercising it. The county court cannot direct my operational decisions without the Dam Safety Office's written concurrence. The Dam Safety Office has not concurred in any direction to restore the reservoir to operating pool. The outlet stays where it is." Garrison had said, "The detention pond is approaching overflow." Emmett had said, "I know. I've been monitoring it from the county road. At the current trajectory and normal July precipitation patterns, the pond will reach its overflow weir elevation in approximately 8 to 12 days. When it overflows, it will discharge to Crestfall Creek through the overflow weir's uncontrolled spillway. The discharge will be within the creek's channel capacity. It will not flood properties. But the pond's overflow condition will be visible to every resident in your development's southern section, and it will be in the county engineer's maintenance records." Garrison had said nothing for a moment. Emmett had said, "Ruth Alcott's number is in the demand letter." He had ended the call and had written in his engineering log, Day 12, July 7th. Call from Garrison Webb. He acknowledged drainage effects, referenced detention pond approaching overflow, advised, outlet within licensed operational authority, TRO suspended, DSO concurrence required for any operational direction. Demand, outstanding. Ruth Alcott's number provided. Reservoir, 12.4 feet. Detention pond freeboard, estimated 1.2 feet. Standing water, persistent at LP1, LP2, LP3. Matter, proceeding. He had gone to the dam at dusk on day 12 and had stood on the crest. The July evening warm, the reservoir at 12.4 feet, the drawdown visible in the exposed band of reservoir bank above the waterline, the outlet running steady in the downstream channel below. 600 feet south, the development's detention pond sat at 1.2 feet of freeboard. The standing water at 3 street low points, documenting in physical terms what the 2004 Stormwater Plan had described in engineering terms 17 months before the first violation notice arrived. The drainage dependency had never been theoretical. It had been in the county engineer's files since 2004. Garrison Webb had been fining the operator of the structure that proved it for 6 months. The water did what you told it to do if you asked correctly. He had been asking correctly for 40 years. He went inside. The document structure was the structure of an agency that understood its statutory authority completely and intended to make that authority legible to a judge who had demonstrated, by the issuance of the show cause order and the temporary restraining order, that he did not yet understand it. The first section was titled, Jurisdictional Authority of the State Dam Safety Office over Licensed Dam Structures. It cited Section 34-201 of the State Dam Safety Statute, the definitional section establishing the office's regulatory jurisdiction over all dams meeting the Class B size and hazard threshold within the state, and Section 34-217, the preemption provision, which Howard Pell's legal counsel had reproduced in full. The State Dam Safety Office has exclusive regulatory jurisdiction over the construction, operation, modification, and removal of Class A and Class B dam structures licensed under this chapter. No court of general jurisdiction, administrative body, local governmental entity, or private party may order, compel, or prohibit the construction, operation, modification, or removal of a licensed Class A or Class B structure without the prior written concurrence of the State Dam Safety Office. Any order, directive, or action purporting to affect the operational status of a licensed structure without the office's written concurrence is void and without legal effect. The section's concluding paragraph stated the office's position without qualification. Cross Pond Dam, operating under DOL-2022-041, is a Class B licensed structure, subject to the exclusive regulatory jurisdiction established by Section 34-217. The County District Court lacks authority to order the removal, modification, or operational cessation of this structure without the office's prior written concurrence. The office has not issued and does not intend to issue concurrence in any removal order affecting DOL-2022-041. The removal counterclaim filed by the Ridgeline Hollow HOA is preempted by state statute and cannot be adjudicated by the County District Court without the office's concurrence. The second section was titled The Licensed Operator's Sole Operational Authority. It cited the Sole Operator Authority provision of DOL-2022-041 directly and addressed the county court's temporary restraining order. The TRO issued on date purported to prohibit the licensed operator from making modifications to the dam structure or outlet works. This directive falls squarely within the category of orders the sole operator authority provision identifies as void. It purported to compel an operational decision without the Dam Safety Office's written concurrence. The office notes that the licensed operator's subsequent adjustment of the outlet works was within the licensed operational parameters of DOL-2022-041 and was not in violation of any valid court order. The TRO having been void at issuance under Section 34-217. Ruth had read that paragraph twice and had called Emmett. The office just told the court that the TRO was void at issuance. Pell's legal counsel put it in writing in a filed document. They are not hedging. Emmett had said, Pell's office issued that license. They're not going to allow a county court to void it through a general jurisdiction order. This is institutional protection of their statutory authority, not just protection of my license. The third section addressed the HOA's CC and R theory directly, an intervention Ruth had not anticipated from a regulatory agency filing, but which Howard Pell's legal counsel had apparently determined was necessary to make the jurisdictional picture complete for Judge Fenn. The section stated, the office takes no position on the contractual interpretation of the HOA's CC and Rs. However, the office notes that no recorded covenant, HOA regulation, or private contractual instrument can expand or supersede the exclusive regulatory jurisdiction established by Section 34-217. Even if the HOA's CC and R covenant were construed to apply to Cross Pond Dam, a legal question the office does not address, that covenant could not create enforceable authority over the dam's operational status beyond what Section 34-217 allows. The HOA's removal claim, whatever its contractual basis, is preempted by state statute, regardless of how the CC and R's geographic scope is interpreted. Ruth had highlighted that paragraph in her copy of the filing and had noted in the margin, agency says, even if Morse's Section 9.2 theory somehow worked, preemption kills the removal claim anyway. Two independent grounds of defeat for the HOA. Fenn has no path to issuing the removal order. The county engineer's statement had been filed 2 days after the dam safety office's position. 3 pages, signed by the county engineer. The caption identifying the filer as an interested party, submitting factual information relevant to the proceedings under the county's Public Works Authority. The statement's first paragraph identified the document at issue. The Ridgeline Hollow Subdivision Stormwater Management Plan, prepared by engineering firm in 2004, filed with this office on date, and incorporated into the subdivision's grading permit conditions, contains specific design assumptions regarding upstream watershed impoundment capacity that are directly relevant to the factual questions in the above-captioned proceeding. The second paragraph reproduced the 2004 plan's relevant language in full, the passage on page 14 that Emmett had read in December 2021 and had noted in his pre-purchase engineering assessment. The Ridgeline Hollow Detention Pond is sized at 38 acre-feet of active storage capacity, sufficient to attenuate peak flows from the development's 47-acre contributing drainage area under a 25-year storm event. The upstream watershed draining to the detention pond via Crestfall Creek encompasses approximately 1,200 acres of predominantly undeveloped watershed, with natural impoundment features estimated at 80 to 120 acre-feet of passive storage capacity. This upstream impoundment capacity attenuates Crestfall Creek's peak flow contribution to the detention pond, allowing the detention pond to be sized at 38 acre-feet rather than the 65 to 80 acre-feet that a direct connection watershed of equivalent size would require. The design assumes the continuation of existing upstream impoundment conditions. The third paragraph stated the county engineer's factual findings regarding Cross Pond's construction. Cross Pond Dam, constructed in fall 2022 under state permit and DOL-2022-041, created a 210 acre-foot reservoir on Crestfall Creek, upstream of the Ridgeline Hollow development. This construction increased the upstream impoundment capacity available to attenuate Crestfall Creek's peak flows from the estimated 80 to 120 acre-feet assumed in the 2004 Stormwater Management Plan to 210 acre-feet, an increase of 75 to 130 acre-feet above the 2004 design assumption. Cross Pond's operation at its normal 18-foot pool elevation improves the Ridgeline Hollow development's drainage performance beyond the parameters the 2004 plan was designed to achieve. The fourth paragraph addressed the current drainage conditions directly. This office has been informed that Cross Pond is currently operating at approximately 60% of its normal operating pool elevation, reducing its available upstream storage to approximately 126 acre-feet. This office's review of the development's drainage infrastructure indicates that the recent standing water observed at 3 low-point locations within the development following a July precipitation event is consistent with reduced upstream attenuation capacity. The reduced upstream storage capacity resulting from the current outlet adjustment is producing drainage conditions that approach the design limits of the 2004 Stormwater Management Plan. The statement's concluding paragraph was the most direct sentence the county engineer's office had produced in the proceeding. The Ridgeline Hollow HOA's enforcement action, which targets the structure responsible for improving the development's drainage performance above its design parameters, is, from a stormwater engineering perspective, structurally counterproductive to the interests of the development's residents. Ruth had read the county engineer's statement the afternoon it was filed and had called Emmett. She had said, "The county engineer just told the court that the HOA is finding the operator of the structure that makes their drainage work, in engineering language, in a filed document." Emmett had said, "The county engineer read the 2004 plan before he filed that statement. He knows what page 14 says." Ruth had said, "The HOA's case is losing in court on 2 legal grounds, and it is also losing in the public record on the engineering facts." Emmett had said, "It was always losing on both. The legal framework and the engineering facts have been consistent since December 2021. The court record is just catching up to the file I've been building for 18 months." Judge Fenn had issued his order, staying the HOA's removal counterclaim, on the Monday following the Dam Safety Office's filing, a 1-page order, terse in the manner of a judge who had read the agency's position, and understood that the path he had started down with the show cause order and the TRO required immediate correction. The order read, "The State Dam Safety Office has filed a statement of agency position advising that the County District Court lacks authority under state statute to order the removal of Cross Pond Dam without the office's prior written concurrence. The office has stated that it will not concur in such an order. The HOA's removal counterclaim is stayed pending resolution of the jurisdictional question at the scheduling conference. All prior operational directives issued by this court affecting Cross Pond Dam's operational status are suspended. The removal counterclaim was stayed. The declaratory judgment action on the jurisdictional and fine validity questions remained active and proceeding to the scheduling conference. Morse had called Garrison after reading Fenn's stay order and had said, "The removal path is effectively closed. The Dam Safety Office has exclusive jurisdiction and will not concur in removal. I advised against the counterclaim before we filed it." Garrison had said, "What about the declaratory judgment action? The fines?" Morse had said, "The fines are the jurisdictional question. Ruth Alcott has been right about since March. I have not found a legal theory that makes Section 7.4's geographic scope language include a property outside the HOA's plat boundary. The declaratory judgment action will resolve the fine validity question, and Emmett Cross will win it." Garrison had said, "So we're done." Morse had said, "On the removal claim, yes. On the fines, yes. On the jurisdictional question, yes. What remains is whether the HOA negotiates the drainage easement and maintenance agreement or waits for the declaratory judgment order. The reservoir is at 60%. The detention pond's overflow threshold is 8 inches away. The development's drainage conditions will continue to produce standing water at the 3 low points during precipitation events until the reservoir is restored to operating pool." Garrison had said nothing. Morse had said, "Ruth Alcott's demand letter offered a recorded drainage easement and dam maintenance agreement as the resolution. That offer documented the relationship between Cross Pond's operation and the development's drainage performance. The offer is still on the table. It hasn't been withdrawn. The question is whether the board wants to negotiate that instrument or wait for a court declaration that the fines were void and deal with the drainage conditions in the meantime." Garrison had called the board meeting for the following Tuesday. Patricia Vance had submitted a written statement to the board before the meeting. 2 pages, precise and without rhetorical ornamentation. The statement of a retired landscape architect who had watched the detention pond's freeboard drop 8 feet in 3 weeks and had read the county engineer's filing in the court record. The statement's final paragraph read, "The board voted 5-0 to reject the demand letter, file the counterclaim, and tell 110 households the dam would come down. The dam is not coming down. The state says so. The county engineer says we need it. The question before the board now is whether we acknowledge that reality before or after the detention pond overflows. The reservoir held at 12.1 feet, the outlet gate 1/4 open, the drawdown having reached its approximate target elevation, and Emmett holding it there by maintaining the outlet flow balanced against the current inflow rate. He had driven to the county road observation point on the morning of the board meeting and had read the detention pond's water surface through the telephoto lens. 0.8 feet of freeboard remaining. The overflow weir was 8 inches away. The July precipitation forecast showed another event possible within 4 to 6 days. He had noted in his engineering log, July 18, 2023, reservoir, 12.1 feet, holding, detention pond freeboard, estimated 0.8 feet, HOA board meeting tonight, agency filings complete, DSO position filed, county engineer statement filed, removal claim stayed, outlet, nominal at 60%, board has Morse's assessment, Patricia Vance's statement, and 8 inches between their detention pond and overflow. The record is complete. The resolution is theirs to make. He had gone back to the dam that evening at dusk, the July light long over the ridge, the reservoir at 12.1 feet, the drawdown band exposed above the waterline on the reservoir's upstream face, the outlet running steady below. 600 feet south, the development sat in the warm July evening, its detention pond 8 inches from its overflow weir, its 3 street low points dry after a week without rain. The next weather system 4 days out. The water did what you told it to do if you asked correctly. The board had a meeting to get to. He went inside. The declaratory judgment hearing had been set for a Thursday morning in August. Courtroom 4, County District Court, Judge Fenn presiding. The docket cleared for a half-day proceeding. Ruth had arrived at 8:30 with 2 banker's boxes and a 12-page exhibit index. Morse had arrived at 8:50 with a legal pad and the expression of an attorney who had advised his client against every significant decision that had brought them to this room, and was now present to advocate for those decisions anyway. Garrison had sat at the plaintiff's table in a pressed shirt, the posture of a man who had organized a model enforcement framework and intended to defend it, regardless of what his attorney had told him in private. Judge Fenn had opened at 9 and had given Ruth the floor. She had taken 40 minutes. She had not raised her voice. She had not editorialized. She had moved through the exhibit index in sequence, DOL-2022-041, the State Dam Safety Statute's preemption provision, the Ridgeline Hollow CC&R text, with Section 7.4's operative language underlined, the HOA plat boundary diagram, the county assessor's parcel map with the 600-foot gap marked, the 6 violation notices with their accumulated fine balance, the Dam Safety Office's formal position, the county engineer's statement, the 14-day outlet reduction log with the detention pond freeboard readings, and the 3 low-point standing water photographs. She had presented each document, stated its relevance in 1 or 2 sentences, and moved to the next. At the end, she had said, "The HOA has no jurisdiction over Emmett's property. Every fine is void. The removal claim is preempted. The drainage dependency is documented by the county's own engineer. The court has everything it needs." Morse had taken 25 minutes. He had presented Section 7.4's environmental character purpose, the aesthetic impact of an industrial reservoir on a natural watershed setting, the 110 households who had purchased homes in a community whose covenants were designed to protect exactly this kind of environmental condition. He had not returned to the Section 9.2 adjacent property theory. He had not addressed the drainage dependency documentation. He had not addressed the Dam Safety Office's preemption position, except to note that the HOA respected the state's regulatory authority while maintaining that the CC&R covenant reflected a legitimate community interest the court should weigh. Judge Fenn had waited until Morse sat down and had looked at his notes for a moment. Then he had said, "Mr. Morse, does the Ridgeline Hollow HOA have any jurisdiction, any recorded covenant, any legal instrument of any kind, over property outside the Ridgeline Hollow plat boundary?" Morse had said, "The HOA's position is that the covenant's environmental character purpose extends to conditions affecting the community, regardless of strict boundary." Fenn had said, "That's not what I asked. Does the HOA have any jurisdiction over Emmett Cross's property?" Morse had looked at his legal pad. He had said, "No." Fenn had written something and had said, "That's what I thought. Give me 15 minutes." He had returned in 12. He had read his order from the bench without preamble. The declaratory judgment order ran to 8 points. The court declared that the Ridgeline Hollow C, and RS, including Section 7.4 and Section 9.2, applied exclusively to properties within the Ridgeline Hollow subdivision plat, and created no enforceable obligations against Emmett's parcel or any structure thereon. The HOA's enforcement action against Cross Pond Dam was ultra vires, beyond the HOA's legal authority, from the date of the first violation notice. All 6 violation notices were void. The $70,000 fine balance was void and unenforceable. The HOA's removal counterclaim was preempted by state statute, as confirmed by the Dam Safety Office's filed position, and was dismissed with prejudice. Point 7 had been the one neither Ruth nor Morse had anticipated. The court, having reviewed the county engineer's stormwater management statement and the 2004 plan's design assumptions, found that the Ridgeline Hollow development's drainage infrastructure had been designed with reference to upstream impoundment capacity, and that Cross Pond's construction had materially increased that capacity above the 2004 design parameters. The HOA was ordered to negotiate in good faith a recorded drainage easement and dam maintenance agreement, acknowledging the reservoir's role in the development's stormwater management within 90 days of the order's entry. The easement and agreement were to be recorded against the HOA's common area parcels in the county deed records. Point 8. If the HOA failed to negotiate and execute the recorded instruments within 90 days, the court would issue a supplemental declaratory finding that the Ridgeline Hollow Development stormwater infrastructure had no established legal right to discharge into or rely upon Cross Pond's impoundment capacity, and the licensed operator's operational decisions regarding the reservoir's pool elevation would be entirely within his discretion under DOL-2022-041 without further court involvement. Garrison had sat at the plaintiff's table, reading the order's 8 points, with the stillness of a man whose model enforcement framework had just been declared void in its entirety by the judge he had asked to enforce it. Morse had not said anything. Patricia Vance, who had attended the hearing from the gallery, had written a single word in her notepad and had closed it. Ruth had walked out of the courthouse at 11:40 into the August morning and had called Emmett, who was at his engineering office 20 minutes away. She had said, "Full declaration. All 8 points. Fines void, enforcement ultra vires, removal dismissed with prejudice, 90-day easement negotiation order. Point 8 as the backstop." He had said, "Point 8. She had said, "The court wrote the backstop into the order without us asking for it." Fenn understood what the Outlet Works Authority meant after reading 14 days of gauge logs and 3 standing water photographs. He put it in writing. Emmett had driven to the dam that afternoon. The reservoir was at 12.0 feet, holding at 60%, the outlet gate 1/4 open, the summer afternoon warm on the exposed bank above the waterline. He had gone to the outlet works at the downstream face, crouched beside the hand wheel, and turned it. Slow, deliberate rotations, the gate closing against the outlet pipe's face, the downstream discharge diminishing and then stopping as the gate seated fully closed. He had stood and had read the staff gauge, 12.0 feet. The inflow would rebuild the reservoir over the coming days. Crestfall Creek's August base flow returning the pool to 18 feet in approximately 10 to 12 days without the outlet's counter discharge. He had written in his engineering log, August 24th, 2023. Declaratory judgment entered. Full declaration. All counts. Fines void. Enforcement ultra vires. Removal dismissed with prejudice. Easement order. 90 days. Outlet gate. Closed. 12:07 p.m. Reservoir. 12.0 feet. Rebuilding to operating pool. Estimated return to 18.0 feet. September 3rd to 5th. He had stood at the downstream face for a moment. The gate sealed, the downstream channel returning to its natural base flow, the reservoir beginning its slow climb back toward the Morning Glory Spillway's inlet ring, toward the full 210 acre-feet that had been keeping Ridgeline Hollow's streets dry since December 2022, while its president sent violation notices to the man who built it. He drove back to the office. He had a drainage easement to negotiate. Garrison had submitted his resignation by email on the Friday after the hearing. 4 sentences to the board, no elaboration, no characterization of the proceedings' outcome, no comment on the 6 months of void enforcement, or the removal claim, or the counterclaim his attorney had advised against filing. He had copied the management company and the community forum moderator. The email had been posted to the forum within the hour. Patricia Vance had read it at her kitchen table, and had not written anything in her notepad. The board had appointed an interim president by Saturday afternoon, a resident named Carl Dietrich, Unit 47, a retired civil engineer who had read the county engineer's stormwater statement the week it was filed, and had called Morse's office the following Monday to ask whether the board understood what page 14 of the 2004 plan said. Morse had told him the board was aware of the drainage dependency documentation. Dietrich had said, "I'm asking whether they understood it." Morse had not answered. Dietrich had called Emmett on Sunday morning, 2 days after Garrison's resignation, 6 days after the declaratory judgment order. He had said, "Mr. Cross, Carl Dietrich, interim president, Ridgeline Hollow HOA. I want to resolve this inside the 90 days. Emmett had said, "Call Ruth Alcott. Her number is in the demand letter. She's been ready to negotiate the easement since June." Dietrich had said, "I read the 2004 plan, page 14, before I called you." Emmett had said, Then you understand what needs to be in the recorded instruments. Dietrich had said, I do. I'll have new HOA counsel call Ms. Alcott this week. The HOA's new counsel was a water rights and land use attorney named Sandra Cho, retained by Dietrich specifically because her practice included HOA covenant work and stormwater easement drafting, the two disciplines the matter required, and that Morse had not brought to the representation. She had called Ruth on Wednesday and had said, I've read everything in the court file. I'm not going to relitigate what's been declared. I want a clean instrument that records correctly and holds up. Ruth had said, so do I. Let's start with the easement's legal description. They had finished in 4 weeks, 8 drafts, 2 in-person sessions, 1 call with Howard Pell's office to confirm the Dam Safety Office's maintenance inspection schedule, and the cost-share methodology the agreement would reference. The instruments were 2, a drainage easement appurtenant to the HOA's common area parcel, running with the land, recorded against the HOA's common area in perpetuity, and a dam maintenance agreement setting out the HOA's cost-share obligation for Cross Pond's 7-year state inspection cycle, the maintenance log access protocol, and the operational communication procedure for significant pool adjustments affecting the development's drainage performance. The drainage easement's recitals acknowledged in recorded language what the county engineer's statement had established in filed language, that Cross Pond's reservoir provided upstream impoundment capacity that attenuated Crestfall Creek's peak flows to the Ridgeline Hollow Detention Pond, that this capacity exceeded the 2004 Stormwater Management Plan's design assumption, and that the HOA's common area drainage infrastructure relied on that capacity as part of the development's functioning stormwater system. The easement granted the HOA a permanent appurtenant right to that attenuation benefit, as long as Cross Pond operated under a valid dam operating license, and it granted Emmett the recorded acknowledgement that the HOA's drainage system depended on his reservoir, language that would run with the HOA's common area parcel through every future board, every future president, every future enforcement committee that might read the CC&Rs and look upstream. The compensation provision was in the maintenance agreement's final section. The HOA would pay Emmett's documented legal costs for the declaratory judgment proceeding and the 6 months of demand letter correspondence, plus a lump sum representing the voided fine balance as acknowledgement of the ultra vires enforcement, not as damages, which Ruth had not pursued, but as a recorded acknowledgement that the fines had been void from the first notice, and that the HOA's enforcement action had been without legal authority from January 3, 2023 forward. Sandra Cho had negotiated the characterization language carefully. Ruth had held the substance without compromise. The instruments had been executed at the county recorder's office on a Tuesday morning in late September. Ruth and Sandra Cho at the recorder's counter, the HOA's management company representative with the executed originals, the recording fees paid, the deputy recorder's stamp going on to both documents in sequence, the instrument numbers assigned and entered into the county deed records. The drainage easement recorded first, then the maintenance agreement, both appurtenant to the HOA's common area parcel, both running with the land. Ruth had called Emmett from the recorder's office parking lot at 10:18 a.m. She had said, recorded, both instruments, easement first, agreement second. Instrument numbers are in the confirmation the recorder's office will email this afternoon. He had said, send me the confirmed copies when they arrive. She had said, the compensation payment clears escrow today. It'll be in the trust account by end of business. He had said, noted. She had started to say something else and had stopped. After a moment, she had said, 18 months from the permit application to recorded instruments. You had the legal framework in your project file before you broke ground. He had said, the framework was in the regulatory bulletin. The drainage dependency was on page 14 of the 2004 plan. The parcel boundary was in the deed records. Everything was already in the public record. I read it. She had said, I know. That's what I mean. He had gone to the dam the following morning, the October dawn cold on the ridge, the first light coming over the eastern tree line, the reservoir at 18.0 feet on the staff gauge, the outlet gate sealed at fully closed, the Morning Glory spillway's inlet ring sitting just below the still water surface, the pool within 2 inches of its overflow elevation, the reservoir full after 6 weeks of rebuilding from the August drawdown. Crestfall Creek moving downstream through the bedrock crossing channel. The flow at its October base flow rate. Lower than July, the seasonal recession begun. The creek doing what it did every October in this watershed. He had walked the crest from the left abutment to the right. The standard morning inspection sequence he had followed every time he visited the dam since the first impoundment in December 2022. The same sequence he would follow for the duration of the license. Embankment surface, clean, no seepage, grass maintained. Crest elevation, within survey tolerance. Outlet works, sealed, no visible leakage at the gate face. Morning Glory spillway, clear, no debris at the inlet ring. Downstream face, dry, no boils, no wet areas. Abutment contacts, tight, no separation. He had stood at the crest's midpoint and looked at the reservoir, the full 210 acre-feet at operating pool. The water surface still in the October calm, the ridgeline reflected on the water. 600 feet downstream, ridgeline hollow streets were dry. The detention pond was at its normal October operating level. The three low points that had stood in water during the July precipitation event were dry and would remain dry through whatever the fall brought. The 210 acre-feet of upstream storage, doing in October what it had done since December 2022, attenuating Crestfall Creek's peak flows before they reached the development's drainage infrastructure, performing above the 2004 design parameters, keeping the streets dry for 110 households whose HOA had spent 6 months trying to find the man responsible for it. He had opened his engineering log at the crest and written the morning's entry in his standard format: date, reservoir elevation, outlet position, license status, structural observations, any notes of significance. October 1st, 2023. Reservoir, 18.0 feet, operating pool. Outlet, sealed, nominal. License, DOL-2022-041. Current. Embankment, sound. Spillway, clear. Downstream face, dry. Fines voided. Easement recorded. License current. Matter, recorded. He had closed the log and stood for a moment at the crest in the October morning, the reservoir full behind him, the creek moving below, the drainage easement now in the county deed records appurtenant to the HOA's common area parcel, running with the land, permanent. He had read the 2004 plan in December 2021. He had noted the legal framework in February 2022. He had broken ground in April. The instruments had recorded in September 2023. Every step between those dates had been in the project file before the first shovel moved. He walked back to the truck.